Living Well's producing this we're putting this on for Leigh Hilton. Short story, true. My mother passed at a very early age in my life. I was 21, she was 42. Passed on an Easter Sunday, supposed to see the cardiologist on the following Monday. Didn't make it. Left my father without a will, and he had to go through all kinds of steps in order to get that straightened out. Fast forward about 25 years, and my wife's father passes away, and he's 67. He knows better. He's an educated businessman. He's got multiple businesses all over the place, and he passes, and no will. Left a bunch of people, all in a big mess. But anyway, Lynn and I have been fully vaccinated since then, and we have drank the Kool-Aid, and we are pretty well healed with our situation, I thought. So when I knew Leigh was coming, I started just thumbing through mine, and everything I have is read in the state of Colorado. And I talked to my attorney friend, and he says, "You're going to probate." So I said, "No, I'm not. I'm going to fix that right now." So anyway, I'm not going to probate. But that's the reason this it's important to have. Even like this was 7 years ago, I had this done, and it's good just check back, every now and then. But anyway, I'll shut up. Leigh, it's your floor.
All right. So I'm going to talk to you guys a little bit about. Oh, does this sound volume-wise? Does it sound loud, you guys? Okay.
I think we're going to be stuck with.
Okay. We're going to be stuck with loud unless you want to step out. Can you step out and ask my son to come in to try to turn the volume down just a little bit? By the way, the guy handing out books, the younger guy handing out books for my son. So that's who's going to come up and figure out volume. My eyes aren't good enough. That actually says all kinds of things with a whole bunch of dials right here. Right, can you turn me down just a little bit? Volume-wise. Okay, so is that better? It's still kind of loud though. What about now? Yes, it sounds good. Back row, can you still hear me?
Yeah.
Okay, somebody said too soft. Somebody said something too soft? We're good? Okay. All right, we're good. All right. Yeah. So before the pandemic, I was giving 3 or 4 speeches a month. And one of the things I learned is that there's always, every speech, there's going to be at least one thing that goes wrong. So the volume being too loud at the beginning, let's agree that that's my one thing. Nothing else in this speech is going to go wrong. It just kind of keeps you a little bit more peaceful if things kind of get glitchy, if you know that there's probably going to be some glitchy things here or there. So I'm going to talk to you guys a little bit about who gets your stuff when you die. It's also 14 secrets to protecting the 2 most important things in your life. Everyone you love and everything you own. So when I was coming up with a tagline a long, long time ago when I first started practicing law, one of the things I was looking for is what do my clients have in common? And if you think about it, all of us have in common that we want to take care of everyone we love. And that even includes ourselves and how we put things together. And I'll talk to you about making sure that not only do we take care of those we're taking care of, we also want to make sure we're taken care of if something happens. The other thing that we have in common, or most people do, is you've worked all your life to accumulate assets. Is it going to bother you if it gets blown within 1 year? And I'm going to tell you something that's kind of depressing, which is most inheritances are treated exactly like lottery winnings, which means they are spent within 1 year, regardless of how much money it is. Now, I had a client I represented many years ago, really sweet couple. They both had a small business. They were very practical with money, very good with how they did things. And they were the one couple that I would have picked out for you guys as someone who could inherit money and handle not blowing it within a year. Her mom passed away, and she inherited $800,000. Can you guys guess how much money was left a year later? Not even, it's actually, a lot of people will guess nothing. But the answer is actually less than nothing. Because what they did is they thought $800,000 was more than they would need for the rest of their lives. So they quit their jobs, they put their kids in private school, and they set about spending the $800,000. So a year later, they are unemployed, they've raised their standard of living as far as what they're spending, and they've spent absolutely all of that money. Now I can tell you that's not an isolated story, so we're going to talk about some ways we can make sure that what we work to earn actually gets down to more than one generation. So another title for this speech could be How to Protect Your Family Without Having to Give Up Control. So one of the themes of the last 2 years, with everything that we've been through with the pandemic, has to do with control. So if you realize a lot of what the power struggles that have happened related to the pandemic has had to do with our ability to control what goes on in our lives. But even with your estate and how we do protections, a lot of the things that we're doing is we're trying to do as much protection as possible without you having to give up too much control. Now, one of the slides I'm going to talk to you a little bit about is how to protect assets in case you have to go to the nursing home. And the short answer to that is the only way we can do that is for you to give up control. And like I said, most people don't like to give up control. So it's going to be a matter of degrees of what amount of control are you willing to give up to get certain benefits if we're trying to protect assets. So what you're going to discover in the speech today is ways to promote family harmony, how to leave a legacy behind, and how to protect yourself in case you need care, and how to obtain peace of mind that you've done the best possible plan possible. To protect yourself, protect your family. So this is for you if you're worried about your children getting along after you're gone. The other thing that I found that a lot of my clients have in common is no matter how much your kids can't stand each other, you have a fantasy that someday they're going to get along beautifully. And the other thing that I try to make sure I mention in every speech I give is most families are dysfunctional. Now, some of you are lucky enough that I have to get to your second or third cousins where the dysfunction happens, but most of it is a little closer to home. And when we're putting together a plan, we need to know about your real family. So I had a lady many years ago, she came into me and she told me about her fairy tale son. And her fairy tale son was the greatest guy you could have ever met. Absolute best son in the world. So we put together her plan and we put him in charge of her medically and financially. And then she got dementia. So she's starting to get paranoid, unable to make her own decisions. And then I got to meet her real son. And her real son, even on first impression, you could tell that he was a jerk. Very controlling, very bossy, very abrasive with his mother. And they actually hadn't spoken in 15 years. So part of why I tell you the story is when you're working with an attorney to put together your plan, you need to work with somebody you trust enough to tell about your real family. Because we need to make sure we put the plan together for your actual family. And what's interesting is a lot of people will come in and they expect us to be surprised that your family is dysfunctional. I'm actually surprised when you tell me everything's beautiful and nothing's wrong. Because most families, like I said, there's some sort of stress. Other thing is, even if you're blessed enough to have one of those fairy tale families, and I do represent fairy tale families also, if we put stress on the fairy tale family, we will also see some dysfunction. So you've got 4 kids, they get along beautifully, everything goes wonderful all the time. You put the 4 in charge together, or any 2 of them in charge together, probably going to cause stress. Or you put the oldest in charge of everybody else's money, you're going to cause stress. If you want to cause a lot of stress, you put the youngest in charge of everybody's money, only because they're going to question, why did you not pick the oldest? So I can tell you lots and lots of stories of how we can make dysfunction happen. But the purpose of the plan and what most people want is you don't want to leave a mess behind. If you're worried who's going to take care of you if you need it, because really if you think about it, it's depressing enough to think about who gets your stuff when you die. Part of the question is who takes care of you if you need it? And you've got to make sure you put the right person in place. If you're sick and tired about worrying about your family altogether, and if you're confused by conflicting advice, we live in an age where we can go on the internet and we can find information about absolutely anything. But how do we know it's accurate? only applies in the state we live in. So Texas, every state, all 50 states have totally different laws on how things are done. One of the things that's kind of quirky about Texas is other states actually, if husband and wife own a house together and one of them dies, survivor owns the house. Not in Texas. In Texas, you each own half the house. And when one of you dies, if your deed isn't ordered properly, the survivor has to go to court, probate, some sort of process in order to get the house. So imagine having the peace of mind knowing your family's going to get along, or at least that you haven't made it worse, knowing you're going to be taken care of if it's needed, and having a plan customized to your unique family situation. When I very first started practicing law, I practiced law with an attorney who had 4 forms for his wills. And he made everybody fit in one of those 4 boxes. You need a plan customized to your actual family and how you want things designed. And everybody is a little bit different in what they're trying to put together. So a little bit about the firm. We've helped over 6,000 families protect the assets that they leave behind to their loved ones from divorce, creditors, and lawsuits. We've also helped over 300 families implement the plans that we've designed, and over 1,200 families implement the plans that other attorneys have designed. Now, one of the questions I got recently was, why would I be implementing another attorney's plan? One of the things I'm going to tell you about at the end is a lot of people, when you put together an estate plan, you put it together, you put it on the shelf, you've already had to talk about maybe you're going to die someday, it's kind of depressing, and you just want to forget about it. But really, whoever you work with, it should be a relationship. We meet with our clients every 3 years just to check in and see what's going on with you. Because we want to make sure your plan works when it's needed, and it's designed to do that. So that's part of why we've implemented other people's plans, because the other attorneys design a plan and then just disappear. We're also estate planning attorneys and elder law attorneys. So part of what I'm going to talk to you guys about today is elder law, so Medicaid, veterans benefits. We do that along with who gets your stuff when you're done. So we have 3 locations. If you guys shop at the Kroger's on 407, we have an office behind that in Bartonville. We also have an office in downtown Denton, and we have an office in downtown Aubrey. The book you guys got, the speech you're going to hear today is about 1/8 of the book. And the reason why I know that is because the publisher told me if I transcribed this speech, I would have the book. And the answer to that is no, you don't. You have 1/8 of the book that you have to come up with 8 times the content. So the book you have in your hand has a lot more stories, a lot more examples to help you kind of think through how you want to put things together. I try to cover in the speech a variety of things, so if it's something that applies to you, it's helpful. Usually people pick up on 1 or 2 things that are helpful to their families. Also, we have 2 other books. They're both related to Alzheimer's. One's called Living with Alzheimer's Disease, and the other is Living as an Alzheimer's Caregiver. And if you're interested in those, you can contact our office and we'll mail them to you. So distributing your stuff, choosing who's going to get your stuff and help you can keep it. So if you come into our office to design a plan, we're going to ask you nosy questions about the family. Because I'm looking for, are they responsible with their own money? Would you trust them with your money to take care of you? Would you trust them if you gave them money to take care of themselves? What about their spouse? What about their kids? Because we got to make sure we get to know the family enough that what we put together actually works when it's needed. I'm also looking for, like I said, people you would trust to make medical and financial decisions for yourself. And, like I said, if you have a dysfunctional family, you need to feel comfortable enough to tell us about that. So for the people you're leaving money to, I'm looking at it from a couple of perspectives. One is, are they responsible enough to handle their own money? And if not, we're going to talk about who to put in charge and what standards you're going to put around that. If they are responsible, do you want to protect the money just in case they get divorced, just in case they get sued, or just in case they have creditor problems? And do you want it to go from the kids to the grandkids? Or are you okay with the kids leaving it to their spouse, and then their spouse leaving it to whoever they marry next? So handle the care stuff. What to do if a beneficiary is disabled? Oh, another thing to tell you about the slides. Every one of these slides, I have an hour-long speech related to the slide. So if you'll go to my website, there's videos of those speeches. Because one of the things that I did as soon as the pandemic hit is I started filming speeches. So I think I've got 10, 15 speeches on my website. You can go and watch a speech on any of these if they apply to your family. But most important thing, two most important things, if you have a beneficiary who's disabled and they're on needs-based government benefits like Medicaid, they're only allowed to have $2,000 in their name. So if you had a grandson with a disability and he's living in a group home and you leave him $10,000, he is suddenly homeless until the $10,000 is spent. Then he goes on a wait list, and the wait list to get into group homes is 18 years. Now they would expedite him, of course, and get him probably right back in within but the $10,000 has to be spent before he can get back in. But if instead you leave it to him in a trust, you put somebody else in charge of it, he's allowed to have that money. So we've got to be really careful in how we leave money to people with disabilities. Other thing is, I have people all the time want to, I'll just leave it to his sister. And his sister will definitely take care of him. I can tell you lots of stories of the sister not taking care of him because she resents him for having taken the attention away from the family or whatever. So, or she gets divorced and her husband takes part of it, or there's all kinds of orders. But it's much, much better if it's in a trust that it's clear who it goes to. And this particular area is very complicated. We've got to be careful we do it correctly. And even a couple of small sentences in the trust can totally mess up their benefits. One of the big things that they can't do anymore, people took advantage of it, is they actually took money in a special needs trust that was for somebody with a disability. They took the whole family, I think it was 40 people on an Alaskan cruise with that kid's money. And they said, no, you can't take your whole family. Well, if I have a sentence in there, which I don't, but if I had a sentence in there that said he can go on vacation with his whole family and the trust will pay for it, then that totally disqualifies the trust. Now, like I said, there's a good reason because somebody was obnoxious enough to take the whole family to Alaska. So you've got to be careful. So he can have one paid companion to take care of him on a trip, and you can have language like that. But there's lots of trips, and perhaps you want to work with somebody who knows what they're doing and you have somebody in your family. So step habits. Smart moves if you or your spouse are diagnosed with Alzheimer's or dementia. One of the hardest things, and unless you've been around somebody with this diagnosis, people don't fully understand what it means. From the time you're diagnosed with Alzheimer's and dementia to the point where you can't set up your own estate plan is years. Because to set up a will or a trust, you have to know who your family is. You have to know what your assets are, and you have to be able to hold those two ideas in your head long enough to make a logical decision. Well, I have lots of clients who were diagnosed with dementia or Alzheimer's 5-6 years ago, and they still 100% can meet that test. Now, they don't have good judgment about who they trust with money, but they can still meet the test to do estate planning. Now, I told you at the beginning we were going to talk a little bit about control. So the sooner you make a plan, the more control you have over how your life goes. So when you're perfectly competent, perfectly healthy, everything's good, you can say, in the event I ever become incompetent, these are the people I trust to be in charge. Those dysfunctional people in my family never ever get to be in charge of my money. These are the people I want to have, these are alternates for that. And so you can have that control in how you put it together. As time goes on, and you get further and further along and closer to becoming fully incompetent, you may not have the ability to make that decision anymore. So that's one of the important things is early on to make the decisions. Other thing I recommend is you're going to go through the same stages of grieving as though a loved one died. So one of the things I recommend is as soon as you get a bad diagnosis, we need to talk about your plan and make sure it works for what's happening. Because you might say, listen, in the event I start losing my ability to make decisions, I want to have my best friend be a co-trustee, a person that I can bounce ideas off of, or my oldest son, or my youngest son, or whoever you trust. And that way you get to choose who stands alongside you. You can also choose who takes over in the event you're not able to make your own decisions. Other thing is, with a bad diagnosis like this, one of the hard things with Alzheimer's is 60% of caregivers die first. That means a healthy person taking care of a person with Alzheimer's. Because Alzheimer's, a lot of times, is a long diagnosis. Average stay in a nursing home with Alzheimer's is 8 years. And that's the end of the road. So if you're taking care of somebody 24 hours a day, you might not be going to the doctor, taking care of yourself, those kind of things, because you're taking care of somebody else. So one of the hard conversations we need to have is, what if the healthy one dies first? What are we doing as far as planning? So I've already a little bit talked about what if you're incapacitated, how do we put things together? So real quick, let me tell you guys the difference between a will and a trust. So wills and trusts both specify who gets your stuff when you die. The question is, do we need to go to court if something happens? So if you have a will in place and you pass away, the only way that we get your assets to the people you want them to go to is to go through probate. Now you'll hear from attorneys in Texas that Texas probate is no big deal. And Texas probate is no big deal if you compare it to California or New York or Florida. Because in those states it costs $25,000 to $30,000 to probate a will. And it takes over a year to get it done. Texas, it's it's still a lot. It's $4,000 to $6,000. And it can take up to 6 months. And what I found over the years, and actually part of why I started talking to people about trusts, is I had a year that I had 3 different women lose their husbands in their 50s. All 3 women, like the husbands died suddenly. When I was watching them go through court and I started thinking about it, if my husband died, even though I do 8 to 10 probates a month, would I want to go through this procedure? And my answer to that is no. Because even though it's only 15 minutes in front of a judge, the questions are easy. They're yes and no. We make it as simple as possible. We're still asking, did somebody you really cared about die? Do they have these kids? Do they have these assets? You don't want to have to go through that. So I started looking into and found out about trust. So with a trust, you can still specify who gets your stuff when you die, but nobody has to go to court if something happens. Sorry, I should probably reword that. Other things, and what if you're out of it? So trust says, so my husband and I have a trust. Our trust says we both are in charge. As long as we're both competent and alive, we're both in charge. In the event one of us becomes incompetent, the competent one takes over. In the event we both become incompetent, we've got people named to step in next. Nobody has to go to court. If we had a will instead, if we become incompetent, our kids would have to take us to court and prove in front of a judge that we were incompetent. So healthcare stuff, who's going to make healthcare decisions for you if you can't? So if you were in the hospital unconscious, and you're unable to communicate, who do you want to have make surgery decisions, medicine decisions, what happens to you decisions? Not life or death, but more just everyday decisions along the way. And it's important that you find somebody who aligns with what you actually want done. So I talk to mothers and daughters all the time that tell, mom will say, I don't want to be kept alive on machines no matter what. And daughter will say, mom, I'm going to keep you alive at any cost under any circumstances. Do you know who mom puts in charge? That daughter, every time, almost every time. And so what daughter thinks has been communicated is mom agrees with me. She wants to be kept alive on machines or she wouldn't have put me in charge. What mom thinks she's communicating is I told her what I wanted. She's a good daughter. She's supposed to do what I asked. You're going to be better off picking somebody who aligns with what you want. Other important thing for you to know is if you are appointed to make somebody else's decisions, you're supposed to step in their shoes and do what they would want you to do. It's not supposed to be what you would want them for you. It's what they want for them. Other greatest gift that you can give to your spouse and your kids is to talk through what you want. Now, it used to be 90%, but it's closer to 95% of the people I talk to now tell me they don't want to be kept alive on machines if the doctor says they're terminal. But what every person means by that is a little bit different. So if you've had the conversation with your kids or whoever's making those decisions, you're going to give them the peace of mind that they're following what you've actually said. So in the event they never think I'm going to be able to leave the hospital, always going to be in a bed, not going to be able to be out on my own. I don't want to be on machines, or there's some people that want to be on machines as long as they can still talk. I'm going to have to get there in a second. So I told you I do 3 or 4 speeches a month. I think my voice is out of practice. Now, how did I do that? Did I actually push the button as well? That was weird. Never mind, there's going to be more than one thing that goes wrong. I don't know how many. You guys can count. Just please keep good humor about it. This tickle's driving me nuts. Privacy law, so HIPAA. So under HIPAA, every time you go to the doctor, every time you go to the hospital, and you sign off, you've read their little pamphlet. Do you guys read it? I read the first 4, and then I just got kind of sick of it because I want to be treated. I really do want the doctor to help me, and I'm going to have to sign or we're not doing anything. The reason why the law came into effect is, I don't know if you've noticed, but the doctor diagnoses you with diabetes, and suddenly you get diabetes magazines in the mail. And you get diabetes drug coupons, and they're selling your information. And so now they're having to tell you this. Now they put it in the fine print of that little pamphlet. Now it's somewhat helpful. I mean, if you're buying the diabetes medication and it's costing you a lot of money and you have a $100 off coupon, you may be thrilled that they're sending it to you in the mail. But it is because somebody's gotten paid to give them their information. So under the privacy law, one of the things that a lot of attorneys don't realize that it affects is in your plan, if you've said, my oldest son is in charge of my trust, what if he becomes incompetent? How is your younger son going to know he needs to step in? So our documents actually say when you step in as trustee, you've got to give the next in line access to your medical records so they can look at them and know whether they need to step in. Now the reason why I have that, but I don't think I mentioned, I belong to an organization that's 3,000 attorneys nationwide. So my clients who've moved here from other states, I can coordinate with the attorneys out of the other states to make sure that we've got the documents you need the Texas documents I take care of, but I've got to figure out what the law is in the other state to make sure that they correspond with each other. So I've got attorneys I can collaborate with on that. Also, if you move somewhere else, I can find you an attorney in that other state that will accept my documents and only change what needs to be changed for that state. So the way I learned this is one of those other attorneys had a situation where they had somebody who had stepped in as trustee. That person started making bad decisions. The next in line couldn't get medical information to know if they needed to step in. Because the document said in the event you can show that the current trustee, 2 doctors certified they were incompetent, the next trustee can step in. But if you can't look at the medical records, you can't get medical information, you're not going to be able to step in without fighting in court. So a lot of what we learn from the other attorneys is things like that to make your documents a little bit better than they would be otherwise. So who needs benefits? Just in case you or a family member need Medicaid or veterans benefits later. Again, there's an hour-long speech on the site. The main reason why I want to bring it up is because veterans benefits in particular, most people don't know they're out there. Now, I don't know if when you're discharged and you're in your 20s, they tell you about them and you think you're never going to be old enough to need them, or if they just don't mention them at all. But one of the veterans benefits is out there is veterans can, and there's asset income requirements, that's part of the video. They can get $2,000 a month towards home care, or towards assisted living, or towards memory care. Spouses of a veteran can get about $1,600. Widows of a veteran, it's about $1,100. And a lot of times, that's a lifesaver for the spouse who's healthy, taking care of the veteran in the event the veteran needs care. There is a 3-year look back if you've given away any money, and they only allow you to have about $138,000 in assets. But if you have family land that's been in the family forever, you want to make sure that that doesn't have to be sold for your care. We might talk about putting it in a trust to protect it. Medicaid, as long as there's one spouse at home and the other spouse goes to the nursing home, there are ways to protect most of the assets. If it's a single person going on to Medicaid in a nursing home, we can usually protect half of the assets. And why that's important is the care you're going to get on Medicaid is not the care you're going to want. So if you're a female, and the reason why, so I'll tell you the second one. If you're a female, you're going to want to buy private. And the reason why I'm saying female is not many men go to the nursing home, and so they tend to have a private room. So we don't have to pay extra to get one. But for females, if you have extra money, you're going to be able to buy a private room. Otherwise, you're going to have a room, and it's going to be a little bitty hospital room you have a room in. Also, it's one caregiver to 40 people. So if you want more care than that, you need to have a certain amount of money set aside. Protecting stuff after it's there. So this is for beneficiaries. So beneficiaries, I told you I'm going to ask you questions to find out, are they responsible or irresponsible? If they're responsible, you can put them in charge of their own money, but do it in a way that's protected just in case they get divorced, just in case they get sued, or in case they have credit problems. And you can also make sure, and I've already mentioned this, that it goes kids to grandkids. It goes the way you want it to go. So important stuff, how to communicate your values to the next generation. I told you at the beginning, most inheritances are treated exactly like lottery winnings. If that bothers you, we can do some things to make sure that nobody gets spread out. They can only withdraw a certain amount per year. Other important thing to think about is if you were to leave $1 million to a 25-year-old grandchild, what is that grandchild going to do? Blow it within a year, probably make and travel extravagantly a year or two, money totally gone. So they're not going to be getting a job, they're not going to be finishing college, they're not going to be, so if you have a situation like that, and I have several clients that do this, I encourage you to match earnings. So at least till maybe 35, encourage them to work, and whatever they earn gets matched. And the last one I did, we ended up customizing it a lot. So for the grandkids 18 to 25, it paid for anything they needed, including college. And then 25 to 30, they matched income. 25 to 35, they matched income. And then after 35, they let the grandkids be in charge of the money. We can customize it to anything you want. Like I told you, there was that one attorney that I worked for that had 4 forms. I wouldn't even know the number of forms I have because I change out stuff like this all the time. Because I ask you the questions, what do you want to do? Other important value thing is I have lots of clients that will create pools of money to help the next generation get educated. So I just set one up a while back that was for nieces and great nieces. This person apparently, nieces, pretty much the whole family has females. And so, but for college or trade school. And they wanted to go generation to generation so that every generation has a chance to be educated. And if you're setting up an education trust, I always tell 2 stories. One was a lady named Shawn that I went to law school with. When I met Shawn, we were getting ready for graduation, and Shawn was trying to figure out what her next degree was going to be. And Shawn actually, when we graduated from law school, had actually been in school 18 years from when she graduated from high school. And the reason why is her grandfather set up this wonderful education trust. And the only requirement, Shawn was very, very smart. The only requirement was that you made good grades. You had to go full time and you had to make good grades and it had to be going towards a degree you didn't already have. And so Shawn had already done, by the time she got to law school, she'd already done a doctorate, and then there's a law doctorate too. So after law school, there's a law doctorate. That was the next place she was headed. And I don't know what she did after that. But she was just going to school as long as she possibly could. Now her grandfather may have loved that. There are some people that really love education. But I bet he expected her to work at something. Other one is I had a client who had a grandson who had a different grandparent who had set up a trust, and as long as you were going to school, headed towards a degree, and making good grades, it would pay for all the living expenses. And so he took 1 class per semester and was taking as long as he possibly could to get to his degree because it was paying for everything he needed. So we got to be a little careful. Also, if it's a pool for a lot of people and there's a wide variety of ages, so nieces and great nieces or great nephews or 2 generations, 3 generations, we could have the first set of people that go to school use up all the money. So thinking through that piece of the puzzle. Also, in the plans that we do, there are more charitable gifts than most attorneys. And the reason why is it's really kind of simple. We just ask you Do you want to leave money to charities? Do you have a charity you care about? And a lot of people will say, oh yeah, I give regularly to this charity or that charity. Why wouldn't I leave something out of my estate for that charity? Also in the category of if everybody's gone, where does it go? A lot of times it's charities. Retirement stuff. So your retirement accounts, when they go to a non-spouse beneficiary, and actually even when they go to a spouse, sometimes we put it in something we call a retirement plan trust. So it's a trust designed to hold retirement plans. It has the protections that you can have on it for the divorce, creditors, and lawsuits. And then it can make sure it goes to the people you want it to go to. So let me give you a reason why your spouse would have it in trust. So in the event you or your spouse, or both, have Alzheimer's, dementia, or are just getting older and you get a little worried that your spouse might get remarried and might leave the retirement plans to somebody other than the kids. You can leave it in trust for the spouse, have it be available for the spouse, anything they need or want, but whatever's left goes the way you agreed. So even like in the second marriage, which I'll talk to you about in a minute. Other situation is when you leave the money to your kids, if you want to make sure it goes down to the grandkids, the retirement plan trust also does that. Again, telling you about a short hour-long speech. And I definitely lose my voice if I do all these hour-long speeches at the same time. So finding stuff and organizing stuff, you're going to know where to look, they won't. If you hide money anywhere, write it down somewhere. And it was funny because I brought this up years ago, and I was thinking, I don't have money. And then I went home, and I got the $100 bill out of the kitchen cabinet hiding place. And I was like, oh, I had money. So if you hide money somewhere, it's worth writing it down. And that way your family knows where to look. Now, if you've had a family member pass away, Texas, and I think almost every state, has something called unclaimed funds. So if you go to Claim It Texas, is the name of the website for Texas, you go to claimittexas.org, type in your name, see if there's money there. I did that a number of years ago. It's kind of an interesting thing. I've got two boys. You saw one of them a minute ago. I've got a younger son too. There was a program that if you bought a certain amount in diapers, they would give a certain amount of money towards a college fund. But when I read the rules, I had to get $500 worth of those credits in order for them to open a college savings plan for the boys. So I spent about enough to get $250 in credits on both boys, and then figured I didn't meet the rules and forgot about it. When I searched unclaimed funds for my name, I had $250 for both of the boys from those accounts that had gone dormant and gone into the account. It takes 6 years for money to go dormant, so if you'll search it when the person dies and about 7 years later. If you have a family member that chases interest rates, I have several clients that do this, they have CDs all over the country. So you may end up having to search in every state they've lived in, all over the country. There are companies now that find that kind of money. They'll send you a letter in the mail saying you've got money. If you ever get a letter in the mail that says, we see that you've got money from Edward Jones or Merrill Lynch or something, go to claimittexas.org, see if you've got money there, because you might. There's no reason to pay them to help you find it. Second marriage stuff, how to protect your spouse and your kids. So in a second marriage, if you leave everything to your spouse, I can almost 100% guarantee you you're disinheriting your kids. Because what happens is, your spouse's relationship with your kids is not going to be the same when you're gone. So your spouse is going to probably have legitimate reasons for disinheriting your kids. So instead, what I do for a lot of my clients is we put things in trust for the spouse. Spouse can spend it on anything they need or want. But whatever's left goes the way that the couple has agreed. And I always want to make sure you guys think about it. Now, what I hear from almost everybody when I bring this up is we've been married 50 years. If he dies, there's no way I'm remarrying. But you don't know. You really don't. And 83% of men that lose a spouse remarry. Now, women, I think the reason why more women don't get remarried is we start outnumbering the men. So there's less people around or less choices along the way. You probably already noticed that. So then if you go to an assisted living or an independent living, it's even worse. And definitely once you get nursing home level, it's 30, 40 to 1. I mean, it's definitely a huge ratio. So maybe not gonna get remarried. I used to only talk about this in second marriages until I had one of my fairy tale families. There's a couple I've known for a very, very long time. They were married 65 years. Wonderful, beautiful couple. They have 4, it's when she died, so she passes away right after they had their 65th anniversary. They have 4 beautiful children, lots of grandchildren, lots of great-grandchildren. Everybody gets along, nothing ever goes wrong. Wife passes away. I guess something went wrong, sorry, something went wrong in the story. So wife passes away, husband reconnects with his high school sweetheart. Really cute story, and a really nice lady. So reconnects with his high school sweetheart, they marry. And they come in, or he comes in to redo his will. And you know who's leaving everything to? His new wife. And I started thinking about it. James and I have been married 32 years. We have the 2 boys together. It would really bother me if I leave everything to him and nothing goes to my boys. And so I now talk about it in first marriages. Because you don't know what's going to happen along the way. Now, the way James and I have ours set up, we have a trust, we're totally in charge together, like I told you earlier. I die, he's in charge of all the money. So I'm not really worried he's going to get swept off his feet and make a bad decision, because if I was, I have to put somebody else in charge. But the other thing you got to realize with that is most things are reciprocal. Meaning, if he dies first, then I have to have somebody else in charge of my money, and as I told you at the beginning, we like control. So it would bother me to not be in control. And like I said, I'm not worried about it. And actually, I hope that I'm in a place that I do not actually know what happens on Earth anymore at the point I leave here. And so maybe it doesn't matter. But I do like the idea of my boys getting something. And I at least want you guys to think about it. Now, the other real important thing is you are in charge when you put together your plan. So whatever you want to do, if you want to put all 4 of your kids in charge together, I'm going to tell you a really, really bad idea. But if you really insist you want to do it, that's what we're doing. If you want to leave it to your spouse outright, then that's fine. I just want to make sure we've thought about it and had a conversation. Sentimental stuff, saving your family, conflict and confusion over the personal property. When I started giving this speech 15 years ago, your kids wanted your stuff. They really don't. But I can almost guarantee you have 1 or 2 sentimental items that they're going to fight over. So there are 2 brothers here in town. They haven't spoken in over 20 years. They both swear that Dad promised them the grandfather clock in the hall. I can almost guarantee you that Dad promised both of them the grandfather clock in the hall. Because if you've talked to enough men about who gets stuff when they die, the most common answer from a man is, I'm going to be dead, I don't care who takes it. So most likely, he didn't really care who got the grandfather clock in the hall. Other scenario that also makes it where he promised it to both is he may have been extremely flattered that they wanted something. That it was his and wanted to remember him by it. But it didn't occur to him that he had the same conversation with both of his sons. And I'm kind of picking on men with it, but women do it with grandkids all the time. So a grandchild comes over and says, Grandma, when you die, can I have that painting? Sure. Next grandchild comes over, exact same conversation. A similar thing, you're flattered they want something. So if you promise somebody something, write it down. If you downsize and sell it, write that down. Because I can tell you lots of family conflicts where the grandkids don't believe that Grandma sold it because they promised them that thing and it should have been there. Other thing is with jewelry, you got to be careful. So if you promise your 1 carat diamond ring to somebody, diamond rings are never 1 carat. They're 0.97, they're 1.03, they're 1.04. Diamonds are never exactly a carat, half carat, whatever. So I've had situations where if somebody wrote down that 1 carat diamond ring went to somebody, the person didn't get it because it was some other slight fraction from that. Other weird quirky one, and I'll get off of this. Wedding ring, engagement ring, 2 different rings. Actually, right now mine is 1, but it's 2 different rings. So if I say I'm giving you my wedding ring, I would really mean both, even if it was 2 rings on my hand. And usually the engagement is the more valuable of the 2 rings. And we've had situations where somebody promises the wedding ring to somebody and they get the gold band, not the one with the diamond. So think through those, maybe take pictures, write it down. Also, if there's a history behind it, a story, no matter how many times you've told people, write that down. I can tell you lots of stories of times when mom dies and the daughter says, Mom told me the story behind this to the point I was sick of hearing it. But now that she's gone, I don't know the details because I always thought she'd be there one more time to tell everything. So I told you, tell me again, keeping your plan current and up to date. I talk to people all the time that tell me, I ask, do you have a will? And they'll tell me, yes. We have a will. We did it when the kids were little. Well, how old are they now? Well, they're in their 40s. And the plan should be designed to work, even as grown-ups. But 2 things. One, when they were little, you had high hopes they were going to be really good, responsible people. Maybe it didn't turn out that way. Second, you probably have them going to live with grandma, and grandma in charge of the money. So we need to probably update, look at it, do things with that. Other thing is they say that 10% of people have a valid will. And that doesn't even mean current, it just means valid. One of the interesting things that's happened in our office since the pandemic is that 90% has suddenly woken up and decided they need a will. And so we're getting calls all the time from people that are in their 90s that say they've never done a will their whole life and they think it's about time to get it done. So I think the media is at least helping with that along the way. But the other question is, has it been 3 years since you met with the attorney who drafted the plan? The other sad thing that I hear a lot of times is when I ask people, do you have a will? Your response is, yes, I have it. I had some guy in Dallas put it together. He was kind of a jerk. I don't even remember his name. But we've got this binder and it looks really official and we're assuming it's going to work. And it might. And it probably was designed to do it. But life happens. So one of the things that we encourage our clients to come in every 3 years, even if you think nothing is different. And let me tell you a story of why that's so important. So I had a client many years ago, he had 2 daughters, and the way he described it is they hated each other from birth. There was no way you could put either daughter in charge of the estate and have it work out well. No way you could put them in charge together and have it work out well. But the son-in-law was a CPA, really good, solid guy. So they were going to put the son-in-law in charge under their plan. And I said, okay, well, I'd like to add language after that that says, if he's still married to your daughter. And they said, oh, no, he's a good, solid guy. Even if our daughter divorces him, he'll still be a good, solid guy. We want him to be in charge. So we come in for the review 6 years later, so it's 2 times from when they did it initially. And they said, hey, we're just coming in, checking up on, telling you about our trips, hearing where you've been, just going to check in on the family, just a social visit, really. Nothing needs to be changed. I said, okay, well, as long as you're here, let's go over your plan. So I start walking through it. And I said, you guys are already ahead of me, so we're already laughing. I said, son-in-law's in charge. And I said, why would we do that? And the moment our daughter brought him home, we knew he was a jerk. Because you rewrite history in your mind. And you probably can remember why he was a jerk along the way, but you just didn't notice it. So we need to make sure the plan's current and up to date and does what you need it to do. So where do you go from here? What most people do is you procrastinate. Yes. You're going to do it someday. I had a guy the other day come in. I had given a speech 15 years ago. And back then I used to hand out a blue folder, so it was before I wrote the book. And he had my blue folder and he'd had it on the shelf for 15 years. And he just recently had a health crisis, and so now he's worried and we're putting together a plan. much better on control if we're putting it together when you're not going to need it anytime soon. Now, we work with people when you're in the crisis trying to get it together soon. But it's going to be a much easier conversation. When we're talking about if you die someday, if you become incompetent, not when. So the next step with our office is to do a family legacy planning session. It's just an initial consult where we get to know you. And I'm not going to go into the full usual sales pitch kind of thing I do towards the end. The main thing, the charge-wise, we usually charge $350 for that consultation. Because you've been to a seminar, which means we've thought about some of the things you're going to have to decide, we charge $97 for that initial consultation. Other thing to be aware of is because the other 90% has figured out they need a will, we're booking into about September. So even if you think you want to talk about it sometime in the fall, we need to get that done ahead of time. That's more sales than I meant to do, so sorry about that. Questions?
You mentioned that when one spouse dies, the house would not go directly to the other spouse, but if you have a lady or a document, would it directly go over the minute the investment?
So her question was, if I said that between spouses, houses don't automatically go to the survivor, she said, what if you have a Lady Bird deed? So Lady Bird deed, for those of you who don't know, is a deed for Medicaid. It's its main purpose. It's to protect the house from Medicaid taking it when you pass away. But it's now called a transfer on death deed. You keep the house for life. On your death, it goes to your spouse or the trust or your kids or your best friend or wherever you want it to go. If you have one of those, that avoids probate. But it's always worth looking at and thinking about all the what ifs. So if I have a transfer on death deed that my house goes to my oldest son and he dies before me, because sometimes that happens, then where does it go next? And that's why a lot of times you're going to want a trust or a will to take care of that. Because they end that way.
If we already have a trust set up and everything, but I've been thinking of changing it, could you take somebody else's trust and look at it and change it to it?
I will look at it and I'll talk to you about whether it does what you want it to do. But if I change it, I have to start from scratch. And the reason for that is there was 2 court cases. They're kind of scary for attorneys. Is the attorneys had gone in on somebody else's trust and made a small change. And there was something else wrong with the trust. And they got sued for not catching the something else wrong. And so if I modify your trust, I'm going to create a new one.
Again, it didn't have to be a new name and all of that.
No, it's the exact same name, exact same original date. Because anything you put in the name of the trust, we don't want you to go through the hassle of putting assets in the trust again. So that part stays in place no matter what.
Okay.
But one of the things that I do with that is that when you come in, I'm going to get to know your family, I'm going to get to know what you want to do. And then I'm going to look at the trust and see if it does it. Because I have people wanting to drop off their trust and ask me, is it a good trust? And the answer most of the time is, yeah, it's a great trust. It leaves everything to your brother when it should leave it to your kids, but it's a great trust. So or put somebody in charge you don't want in charge. So we got to make sure we're lining up with what you want to do.
Okay.
There's one here and then over here, all the way back there and then in front of the you first, and the lady.
If you have beneficiaries on everything you own, do you have to go to probate?
As long as everything you own has a beneficiary on it, you do not have to go to probate. As long as people die in order. So everybody you name as beneficiaries are still alive. I know that sounds facetious, but that's actually happening. All right, lady in yellow, and then that way.
What if you move from one state to another?
Move from one state to another, it's worth reviewing things. So in Texas, I told you guys probate is relatively simple. It takes 4 to 6 months, costs between $4,000 and $6,000 to get it done. Other states more complicated. That's the simple kind of probate. It's called an independent administration. We have 2 types. The other one is called dependent, which means you have to have 3 court hearings to sell the house. It can cost $15,000 to $20,000 to do. If you move from out of state and you don't have the right language, you're signing up for really expensive probate. So that's part of why you need to have it reviewed. No matter what, if you move from out of state, I would recommend you to update your financial and medical power of attorneys, because those are different state to state. And if you want a bank to take the financial power of attorneys or a doctor to accept the medical, you need to be on the right form. So that's why you want to update that. I don't remember who it was, but yeah, I don't think it was you, I think it may have gone to Bill.
You mentioned about the HIPAA document. So lots of times in the document itself will say, who do you want to, name the person that you want to have this information to go to. So wouldn't that suffice? Because you were saying you have to get a special, have to be in your trust to say who gets your medical information. But
So-
right here in the HIPAA, you've already told.
Your HIPAA governs who can look at your medical records. It doesn't govern who can look at your son's medical records. So if your son is taken over as trustee, in order for anybody else to look at his medical records, he would need another HIPAA release. That's what I was trying to point out.
Oh, okay. I see.
I don't remember who it was. There was somebody in this general area that had their hand raised, and then I'll go this way. Okay, all right, never mind, this way.
Okay, so, not to be salesy, but what would you charge for a planning session? Not just a session, but to put it on.
So the planning session, we have 20 different price charts depending on what we're doing. And so because of that, I don't like to quote fees just in the abstract. So pretty much for $97, you're gonna get a lot of really good advice. And honestly, even if you don't hire us, you're gonna be way ahead when you go to the next attorney as far as telling them what you want. And then at the end of that, we quote a fee. I've done it in the abstract many, many times. I promise you, it will confuse you. So ballpark is crazy. Like ballpark really is such a wide range. Because are we planning to see if you go to nursing home one day, we'll protect your money? Do you have a special needs kid? Do you have a kid that's just so irresponsible they can't do stuff? Do you have responsible kids? Are we skipping to go to the grandkids? Are we doing it? There's just so many pivot points that make it really hard to do. Now, if you're looking to spend hundreds, we're not in. So almost everything we do is in the thousands. So that kind of gives you an idea. If you're looking to spend hundreds, you're probably going to have an attorney that does car wreck cases and criminal law and maybe divorces and happens to do those. Yes.
My only question, I already have a trust. If you have to redo it, is that going to be copy and paste mainly? No?
No, what I do is I create the type of trust I would create from scratch. Because I would,
So it's a brand new trust.
It's a brand new
It really
trust.
doesn't matter what we pay for that first one.
right, it doesn't. And I know that's frustrating moving state to state. Now,
Okay.
okay. Even that, it depends on the quality of what the other person did. And I never want to disparage somebody else's quality. But it's a matter of things I like to have in there that are protections. Most attorneys don't put in there. And so there's a lot of things that I would want to put in to improve it. I'm one of those people, a lot of attorneys, they come up with a form when they first graduate from law school, and then they make changes to it, improve it slightly, but they don't start over ever, or add a lot. So mine has a lot of comprehensive stuff. The other last thing, and we'll probably close to done, right?
You're good.
Okay. One of the things that people will say is, why does it have to be so long? I cover everything I can think of. So I cover if the people you're leaving money to end up in a nursing home, how to protect money, if they're in a car wreck and have a head injury, how to protect money, all those kind of things along the way. One more drink and then I'll answer your question.
Excuse me, I mean, you're there. Okay, your medical power of attorney, that's something you sign at the doctor's office and fill it out and get it notarized. Is your living trust have a medical portion in it also?
So usually if you come in to do a living trust, we do medical power of attorneys for you at the same time.
Okay,
Now, Texas, your medical power of attorney is a standard form.
yeah.
So the one you get from the doctor's office is great. You can use that. There's no reason not to. You don't have to pay an attorney to create them.
Right.
Your directive, which is whether you want to become reliable machines, I modify it slightly. I usually have it where a family member and the doctor together make the decision. But the form is the same because it's a standard form in the state. Yes?
Couple of questions. Speaking with medical power of attorney, do they ever expire? Like, are they only good for a certain period of time? 'Cause
No, the only one thing that expires, and I don't know why, but the HIPAA has a 10-year expiration. It's in the statute. But medical does not.
Okay, my other question is, when we set up our trust, our attorney at that time had said to try and keep your trust updated so that if someone in your trust moves and you want them to make sure that your trustee has all their current information. So you would have to more or less amend the trust?
I would put a sheet of paper wherever you keep it that says, my son's address is now this.
Okay,
And
and
his
what
phone
if,
number is now this.
and
So
but what
you
if you wanted to change the beneficiary? or
change beneficiaries, then yes, you would have to update it.
something? Then
Amend it. If the attorney who drew it up can amend it, make a small change, and a new attorney is gonna need to start from scratch.
Okay.
If you have a trust with an outside person, not a family member, because you didn't want to burden one person over, over another, can you change that person pretty easily if you decide that you don't, no longer, they're no longer in business or, you know?
So one of my exceptions to whether I'll amend somebody else's trust is I will do a designation of trustee for you, which means you can change trustees, because I don't have to rewrite the whole trust to do that. So that's a pretty short, it's not even a full page, I think. There's a one-page document we can change who your trustees are pretty easily. It's gonna permeate through your documents though. It goes in your will, it's in your financial power of attorney, it's probably in your medical. So there's a few other documents we need to work out, but we can help you do that.
Good. Thank you. Pat Sherman with DACU, she's up there, our sponsor. They provided the cookies, the refreshments.